Enron trial begins today. The defense teams for former Enron execs Ken Lay and Jeff Skilling will start to make their case in Houston. Can they still get off the hook? Joining us to talk about it, attorneys Michael Wynne in Houston and Howard Myers in New York. Gentlemen, thanks very much for being with us. I will start with Michael in Houston. Has anything changed here? Is Lay still going to claim that he didn't know anything was going on, and is Skilling still going to say there wasn't a crime?
Well, that's going to be kind of difficult and is going to wear thin fairly quickly. I think the two main defense themes are going to be, on the one hand, that they were doing what they were doing in order to try to save the company, and second, that there was a run on the bank that prevented them from doing that. Mr. Lay has a PhD in economics, and listening to the clips from those analyst calls and those employee meetings, he sounds very involved. And of course, Mr. Skilling was deeply involved in the operations of the company. So the claim that they simply did not know what they were doing, especially given the amount of money that they were drawing, is going to wear fairly thin. I think their best chance is probably to allege they're just trying to save the company.
Howard Myers, you see it the same way?
I do. Here, it's going to be an issue completely based on the credibility of these two defendants. There is no smoking gun in this case. There are no emails or documents directly or indirectly tying Mr. Lay or Mr. Skilling to the alleged fraud. To the extent that Mr. Skilling and Mr. Lay can say that they've acted to the best of their abilities, that they were not as involved as these witnesses claim they say they are, they may be able to skate by, but I think it's a real uphill battle.
You think, you say there's no real evidence. Are you saying the state has not proved its case? The prosecution has not proved its case?
No, I haven't said that. With respect to the culmination of witnesses who've testified, it's fairly clear that they've alleged that Mr. Lay and Mr. Skilling were in fact involved and knowledgeable about the inner workings of Enron. To the extent that Mr. Lay and Mr. Skilling's attorney can say that these people just said that to save their own skin, so to speak, because many of these witnesses have already pled guilty to serious crimes.
Michael, how long can we expect the defenses, plural, to take?
They estimated there would be about 4 to 6 weeks, of course. The Lay and Skilling examination and cross-examination is going to be the highlight of this case. Once they take the stand, really very little else matters, because the argument that people were lying in order to try to save themselves some prison time really gets turned on its head once the two defendants take the stand. And the question at that point is whether or not the jury believes them.
And they will take the stand? They will testify?
We've been promised several times that they will testify.
Mr. Myers, if you were their attorney, would you let them testify?
A tough call, but I think in this case you almost have to basically rebut the testimony that's been already set forth in this case.
Mr. Wynne, what about you? Would you put your clients, if they were your clients, I realize they have separate lawyers, but would you put them on the stand?
I think in this case you just have to do it, especially with the circumstances you have. You have Skilling's testimony before Congress, that he's going to have to confront and deal with. And a lot of this comes down to their knowledge at the particular time, and this jury is going to want to hear from these particular defendants, risky as that may be.
Is there anything in the congressional appearances that could help or hurt them? I mean, I don't recall them saying much of anything.
No, but with all those statements out there in the public already, you need to confront it and to present the witnesses.
Howard Myers, is there anything you think this defense needs to do, either positive or negative? Are there any potential landmines that you can foresee that they need to avoid?
Yeah, well, in the opening statements, Mr. Lay's and Mr. Skilling's attorney promised that the accounting was above board. And I think that was a pretty substantial risk they took. And unless they come through and show the accounting was above board in this case, the jury may be scratching their heads saying, you know, show us the money. Where's the problem here?
All right. So what would your chief defensive tactic or strategy be here?
I would essentially try to rip apart the witnesses that have been set forth in this case, show that they had an axe to grind, that they were trying to save their own skins, that everyone was acting in concert, essentially.
I'm sorry, go ahead.
I was just going to finish off and showing that indeed, as was pointed out previously, that Mr. Lay and Mr. Skilling tried to act in the best interest of the company.
Michael Wynne, same question to you. What would your thrust be?
Well, it would be a subtle one to jury nullification, essentially what they're trying to do. Of course, they will try to put the jurors in the shoes of the defendants, particularly Mr. Lay, as the company was going downhill in the fall of 2001. And also use that refrain that there was a run on the bank. The government will come back and say simply Enron was a public company, not a bank. It wasn't in the business, it was supposed to be in the business manufacturing earnings. The government will also point out that no genuine third-party entity would have entered into these types of agreements with Enron. The best defense tactic there is to hammer home that there's no paper trail, there's no smoking gun. That's not the way business is done in America, and if these deals did exist, you would see some type of paperwork or some type of notes, or at least more than the government's presented so far.
All right, gentlemen, thank you very much for your input. Appreciate it.
Thank you.
Michael Wynne with Yetter and Warder, Howard Myers with Myers and Heim.